How does a liability waiver affect assumption of risk in personal injury? Imagine you're about to try a new adventure activity like zip lining or rock climbing. Before you start, you see a firm asking you to sign a liability waiver. Have you ever wondered how that document impacts your ability to claim damages if you get hurt? Well, let's explore how a liability waiver plays a role in assumption of risk and personal injury law. When you sign a liability waiver, you're giving clear permission that you understand the risks involved in the activity. This document shows that you were told about the dangers and agreed to accept them voluntarily. It's like a handshake that says, "I know what I'm getting into, and I accept the risks." This can make it harder for you to sue for injuries caused by those known risks later on. In personal injury law, assumption of risk means that if you knowingly expose yourself to a danger, you might not be able to hold someone else responsible for your injuries. To prove this, you need to show that you knew about the specific risk and chose to accept it. A liability waiver helps prove both parts because it states the risks clearly and confirms your agreement to accept them. There are two main types of assumption of risk. The first is express assumption of risk, which happens when you sign a written waiver. This is common in activities with inherent dangers, like skydiving or whitewater rafting. The second is implied assumption of risk, which occurs when your actions show you understood the risks, even if you didn't sign anything. For example, if you participate in a dangerous sport without signing a waiver, your actions suggest you accepted the risks. Liability waivers are especially useful for activities that are naturally risky. They protect businesses or organizers from being sued for injuries caused by the inherent dangers of the activity. But they don't shield them from injuries caused by negligence or failure to take safety precautions. If the equipment is defective or safety rules are ignored, you can still file a claim even if you signed a waiver. Understanding primary and secondary assumption of risk is important. Primary means you accept the inherent risks, and the organizer doesn't owe you extra protection. Secondary means you accept risks created by someone else's negligence. Even with a waiver, if negligence is proven, liability can still be assigned. Having a signed liability waiver makes it easier to argue that you voluntarily accepted the risks involved. Courts often see these documents as proof that you knew what you were doing and agreed to the risks. However, the waiver must be clear and specific about what risks are involved, and the activity must be properly disclosed. In the end, a liability waiver affects assumption of risk by showing that you understood and accepted the known dangers. This can limit your ability to seek damages for injuries caused by those risks. But it doesn't eliminate all claims. If negligence is involved, you might still have options. So, always read and understand the waiver before signing, and know that it can be a strong defense for the organizer or business in a personal injury case.